piece of housework to do first. I've been advised to implore all of you to consider the fact that when we're all done and our little committee gathers for a post-mortem conference call, quit is going to be just about broke. So if anybody here could be moved to write the word quit on a check with a figure that was nice, generous, and tax deductible, and give it to Scylla, we'd be very grateful, because that's how we're going to keep it together here. And if you have meetings that need some worthy cause to give a little money to, you need to remember, quit. Tax deductible. Not that your meetings need to worry about that. So, that's the one bit of housekeeping business. And so I was going to introduce Scott. To do that, I need to mention how much I've had to learn to get involved and try to get up to speed on matters of torture. I had to come to terms with a lot of unsettling stuff. Gruesome pictures, awful stories. But one of the most unsettling things that I ever had to learn is something that's not easy to explain. I'm going to try to make it brief. It's that the legitimizing of torture in a society like ours involves two things which, at least significantly, cut the fundamental root of whatever we think of as our liberty and constitutional order. Because for the ruler or rulers to be able to say that the rights and protections of the law apply to me and Janet, but not to Aisha, that means that they're making, the government is able to make an exception for some people that make the law, the protections of the law, not apply to them. And if a ruler can do that, can pick and choose to whom the protections of the law apply. And torture is a quintessential example of being deprived of protections of the law. Maybe not the only way, but it's a quintessential one. If a ruler can do that and get away with it, the ruler has moved beyond the law. And if you have rulers that are beyond the law, who are able to take citizens and put them outside the protections of the law, you have the basis of tyranny and police state. And that's where we're at. And Scott Horton taught me that. At the very first torture conference I went to, 2006, in Princeton. I hope you remember, you were tapping on this big fat book by Max Schmidt. And the actual quote, if I remember it correctly, was, translated from German by Scott, "Sovereign indeed is he who controls the exception." Is that about it? Sovereign indeed is he who controls the exception. It's not a gruesome picture. It's not a horrible story. But the more it has sunk into me as what it amounts to when you have torture legitimized, it has been one of the most profoundly unsettling aspects of my long journey, which is now about, well, not 5 years. So, and I learned that from Scott, and it's a measure of the breadth of his learning and study in all his fields. So he's a scholar as well as a lawyer. I don't even know all the languages that he knows. But it's been interesting to follow him, crossed paths with him at a number of other conferences since then. But also he does this blog, which ought to be required reading for all of us. It's called No Comment. It's at the Harper's Magazine website. Has been not only a record of particularly incisive analysis of the unfolding of the matter of torture and accountability, but it's also been a site of a kind of investigative reporting. Because last winter, Scott more or less broke the story about the hidden black site at Guantanamo. He didn't do all the work himself. He had all these college students at Fairleigh Dickinson, is that it?
Princeton.
That did a lot of the work, but he made
Seton Hall, actually.
Seton Hall. I knew it was two names. He brought it out and really got it into circulation. And like most such really startling revelations about torture, it hasn't exactly brought about any accountability yet. But nonetheless, it really enlarged our knowledge of just how really terrible situation at Guantanamo has sunk in many cases. So his work is really, I think, at the forefront of this field that we're laboring in. So I think we are very fortunate to be able to hear from him directly, and I hope, he says he's going to talk about something to some extent that's close to what I have to deal with for Bragg, but by all means, welcome Scott Horton.
Well, thank you very much, Chuck, for that introduction. I want to talk particularly about law, lawyers, legal process, the way this is played into this whole controversy surrounding torture, and I want to approach it in a particular way. That is to say, we're all familiar with what happened in the Bush era, and I think an awful lot of us here accepted the notion of change that we could believe in November 2008. And why is it that that change hasn't really materialized? Or maybe I should present that as a question. Has it? To what extent has there really been change introduced by the new administration? Well, first, what was promised, and then what actually came, and then with respect to the difference, why? And what does that mean with respect to the anti-torture movement in the United States? What do we have to do to refocus our program to try and influence the government? Well, I'm going to start with a quotation from the old days. Actually, from Texas Tech Law Review by Alberto Gonzales. You remember him? Yeah. The Attorney General of the United States. He writes, in late 2001, government officials, he's referring to himself and his colleagues, clearly understood our moral and legal obligation not to kill the captives. That was his distillation of the sum total of the obligation imposed on the Bush administration by international law and the Geneva Conventions. It's grudging, but, okay, not kill them, right? That was it. I think just astonishing. And this is an article published just a couple of weeks ago entitled, Waging War Within the Constitution. It's his apology for what happened during the Bush administration. A number of legal scholars have already suggested the title more appropriately would read Waging War on the Constitution. But in any event, I can reduce it to just a couple of sentences having read it. And I'd say, first of all, don't waste your time reading it because it's eminently forgettable as an article. But it's an attempt to apologize or to justify what happened on his watch, and the justification is essentially this: the security of the United States hinges upon giving the President of the United States unlimited power. So we were fighting a war against Al-Qaeda and Islamic terrorists. We were also fighting a war against those inside the United States who wanted to hamper and limit the president's authority to wage war that was essential for our national security. So it's a rather astonishing view of the Constitution. It's basically reduced the entire Constitution down to the Commander-in-Chief clause. That's it. Everything else is eliminated. That's what's known as the state of exception. I think we have a lot of scholars now who see this. And to me, it's really fascinating that what happened over the Bush era, and in essence, it was a replay of these really dramatic events that occurred in England in the middle of the 17th century, around the time that the Society of Friends was being founded, was being launched during the Civil War and right after the Civil War, Civil War, the English Civil War, revolved around a lot of the same issues we've seen litigated and discussed here, which included, I mean, the whole thing really began with the king's proclaimed war-making power. The king said this was not subject to any sort of limitation by Parliament. The king attempted to suspend the writ of habeas corpus or to undermine it, and so on. You have a whole series of things. And the Civil War was fought over that issue. And of course, the United States didn't exist at that time, but the American colonies were populated with people who there was really no ambiguity whatsoever as to which side they supported during the Civil War. They were against the king, of course, and they were for these restraints. So, in essence, you know, our country, our Constitution, our legal tradition, all springs from that time, from the constitutional movement that was launched by the parliamentarians, by Cromwell, by the Roundheads, the religious fanatics of that age. No, not the terrorists, of course, because the terrorists of that age were, as we all know, the Catholics were the terrorists. So I think that gives us a bit of a feel of the 8 years of the Bush administration. But what about Barack Obama? It's almost immediately after he launched his campaign for president, and that occurred, remember, on Lincoln's birthday. It was on February 10th, 2007. And he issued a stinging criticism of all the legal policies that underlay the Bush administration's war on terror. He took aim first, right off the bat, at the use of torture. He used the word torture repeatedly. He also talked about highly coercive interrogation techniques. He said that these were contrary to American tradition and American policies. That an end need to be put to this. He talked about the CIA's extraordinary renditions program, particularly as it was connected to torture and torture by proxy. He argued that the heavy use of security contractors, armed security contractors, not wearing uniforms, that this was also an immense problem, the fact that there was no criminal law accountability for them. In fact, he introduced legislation in the Senate designed to address that. He decried the practice of warrantless domestic surveillance, probably in breach of FISA. He called the heavy use of state secrecy claims abusive, and he promised that he would rein it in if he was elected. And in general, he promised to, and I quote, to restore the standards of due process and the core constitutional values that have made this country great. And that's a promise that reveals his approach to these issues generally, which is, I mean, he's a law professor. It's a rights-based approach, and it's relatively legalistic, but it is anchored in an understanding of the Constitution that is diametrically opposed to the one that Alberto Gonzales put forward that I just read you a quote about.
When was that? When did he give that talk?
That was during the campaign. In fact, that was in October of 2008. So that was a month, a little bit less than a month before the election. So now we're approaching the second anniversary of the election, which means we're coming up on the midterm elections. And I think there's a broad acceptance, especially among scholars, national security law scholars, both critics and supporters of Obama, that there hasn't been much change in this area, that his policies have generally been a continuation, flatline continuation of the Bush administration policies. So he firmly pledged to shut down the prison facilities at Guantanamo within 1 year. That did not happen. And indeed, there is no shutdown now anywhere in sight. His administration doesn't even want to talk about that anymore. His views on the state secrecy issue, well, a number of scholars looking at that have concluded that he's actually adopted a far more aggressive posture on state secrecy than the Bush administration did. In fact, just one example, we just had I think a horrendous decision come down from the Ninth Circuit in San Francisco, in which the circuit split right down the middle, 6-5, and it reversed a panel decision. Well, that panel decision argued before 3 judges, and when the Justice Department lawyers came in to present their case, the 3 judges said, "Stop. Are you telling us that you're accurately representing the views of Barack Obama, given that he said X," and then they quoted from his speeches during the campaign, and they said, "We're just going to stop this hearing because we don't believe you. Go back to the Justice Department and clarify your instructions before you proceed in this case." And the Justice Department came back and said, no, we're not changing in any way one iota of the position taken by the Bush administration. In fact, we're going to be more aggressive than they were on this issue. And the panel included 3 judges who were in the 5 on the short side of the Ninth Circuit, all 3 judges saying, this is crazy. And they ruled against, they not only ruled against the Justice Department, they ridiculed the Justice Department and its handling of the case. And they also expressed open disbelief of the bona fides of their claim of state secrecy during the proceeding, which I think was very, very well placed. What has he done on his pledge? I think we can say 2 things. Okay, he issued an executive order in the 2nd day in office which banned torture, and his Department of Justice openly repealed the torture memoranda that had been issued in the Bush era. His Attorney General testified that he believed that waterboarding was torture. Justice Department officials have also gone through a whole list of other techniques that were approved during the Bush era and said that they believe that they are unlawful, or that they're very hesitant to use the word torture. So I think when we got a clear reframing of that issue that involved some quite significant movement on these techniques. He also issued an executive order that put an end to the practice of extraordinary renditions connected to black sites run by the CIA. And it's interesting that executive order evidently got tailored in just the last minutes before it was signed. The original order said it put an end to black sites, and as it was signed, it said black sites by the CIA. A lot of people were wondering, well, what's that about? And of course, in the course of the last year, we've discovered, well, actually, there were 2 series of secret prisons operated, one by the CIA and the other operated by a group called the Joint Special Operations Command, based in North Carolina, called JSOC. Their prisons have now been disclosed. We know, in fact, we know 4 or 5 different locations of them, and it appears quite clear that Obama learned about these prisons and authorized them to be continued. And that occurred very early in his administration, and almost all these operations have remained shrouded with exceptional secrecy. And one big distinction I can tell you that can be drawn between the CIA and JSOC is that the CIA actually doesn't seem to be able to keep a secret. Almost everything they do winds up being reported and getting out. JSOC, on the other hand, has a really amazing track record at keeping its secrets, and that's going to be tested, I think, quite severely in the course of the coming month. I'll come back and talk about that a little bit at the end. Whereas in the early months of the Obama presidency, we have Bill Kristol and Liz Cheney mounting a campaign with television advertisements and so on, saying he's putting the country at risk because he's stepping back from the policies that served us so well under President Bush. That's just, counterfactual, shall we say. In fact, there was almost no change. And these policies, we had the change in the use of approved torture techniques. That's about it. And even on that point, the internal investigations by both the military and the CIA had come to a conclusion that the heavy stuff was clearly counterproductive from a military perspective. So we are dealing with an administration that continued almost on autopilot. We have the legacy of Guantanamo that hasn't been brought to an end. And given the firmness and the very dramatic way that Obama made his pledge to end this, his failure to do so is really troubling. And I want to just zero in, because we talk about all this conceptually. I'd like to talk about just one specific case that you may have heard a little bit about. You're certainly going to hear quite a lot more about in the coming months. And I think this one case is very telling in understanding what's happened, how things have continued, and the sort of internal dynamic that's going on. And this case involves Omar Khadr. Omar Khadr was apprehended in 2002 by the United States. He was 15 years old. 15 years old, a child. 8 years later, he remains in prison. He has been charged with homicide and material support to terrorists. The opening stages of that trial have occurred, and we're expecting to see in the next few weeks the continuation of the trial coming to an end and submission to a jury. A number of senior people on Obama's team consider correctly this whole matter surrounding Omar Khadr to be an unmitigated disaster of the highest order. It is severely damaging the reputation of the United States around the world. It's hard to see anything positive that flows from the case. It's, in any event, it's a matter of appalling staging. So even if you approve the idea of the Guantanamo commissions, you want to go ahead with it, it's hard to understand why this case is selected to be the showcase trial in Guantanamo. So let's just look a little bit more at who Khadr is, what's happened in the history of the case. You just get a sense of the inhumanity and the dysfunctionality of this whole system going through the case. Let's start. The first issue that surrounds him is, of course, the fact that he's what we would call in the criminal justice system a juvenile offender. Okay, assuming that there really are valid charges against him. The International Covenant on Civil and Political Rights and international juvenile justice standards require that when you're bringing a charge against a juvenile, it has to be resolved promptly. The assumption in this case is that promptly means 3 to 6 months. Okay, we're 8 years and unresolved in this case. And they also establish a presumption that you don't detain juveniles. It's only done as a last resort in extraordinary cases. So the Khadr case, the way it's proceeded so far, it demonstrates a systematic disregard for these international standards. It took 2 years before Omar Khadr got an attorney. It took 3 more years before any charges were raised against him. While in prison, Khadr was placed in solitary confinement, and he was held together with adult prisoners. Both of these practices absolutely, unequivocally prohibited under the international standards and international instruments. Khadr says while he was held first at Bagram and later at Guantanamo, he was subjected to torture and other highly coercive interrogation practices. And indeed, one of his interrogators at Bagram has stepped forward and testified saying he was tortured. That's his conclusion, and he describes exactly how it happened. So this is already incompetent evidence before the proceeding. And that, of course, violates Common Article 3 of the Geneva Conventions, as well as the Convention Against Torture. Now, in 2002, that is the same year he was captured, the United States ratified the optional protocol to the Convention on the Rights of the Child involving children in armed conflict. And by doing so, the United States agreed that it would stop the service of children, those under 18 years of age, in armed conflict. But it also committed itself to a special regime of dealing with any child warriors, that is, warriors under 18 years of age, that came into its custody. It said that it would treat them as victims of the conflict, and it committed to provide, quote, all appropriate assistance for their physical and psychological recovery and social reintegration. And again, we see this commitment given by the United States right at the time Omar Khadr is captured, and the Bush administration's actions show it views the commitments it gave as a dead letter immediately in the first year it gave them. Instead, Khadr was labeled as an enemy combatant. He was linked to Al-Qaeda at a combat status review tribunal. Now, I think if you go back and you look at the information that's been collected about Khadr and his family, it would be, mildly put, we would say, he came from a dysfunctional family. His family, he was raised originally in Toronto, Canada. He is a Canadian citizen. His father was deeply involved in militant Islamic movements, clearly developed ties to Al-Qaeda, and took his son, then 12 years old, with him to Pakistan and then Afghanistan. And also, the evidence is very clear that he tried to impress, to push his son into service for the military there, for military operations for the Taliban and Al-Qaeda. So I think there's clear evidence of all of this. Of course, on the basis of this information, I think in the criminal justice system, the normal reaction would not be to develop criminal charges against the son, Omar. It would be to bring charges against the parents who allowed this to happen for reckless endangerment. That would be the normal approach, not taken here. The procedural history of this case is very, very convoluted, involving lengthy struggles over access to evidence, competence of the tribunals, and so forth. I don't want to go into all that detail, but that does explain how things dragged on a relatively long period of time. But there are a series of really extraordinary incidents that occurred. One is this. In October 2007, this is just as prosecutors and defense counsel are engaged in a major battle over discovery, that is, especially the defense's access to files, identification of witnesses, right to approach and interview these witnesses. Suddenly, out of the blue, the chief prosecutor, Colonel Morris Davis, resigned. First, not really offering any statement. A lot of people looked at this and saw, well, that's quite interesting, because his resignation is exactly the same day on which the Pentagon put into effect a new command structure with respect to the military commissions. And this new command structure put a man named Jim Haynes at the apex over the courts, the prosecutors, and the defense counsel. Jim Haynes, one of Dick Cheney's favorite lawyers, protege of David Addington, Dick Cheney's chief of staff, was the chief of staff of the Department of Defense. And Davis subsequently disclosed that Haynes and others on his staff had directed a full palette of prosecutions to be put on, and had directed the timing of the prosecutions, and he had told Haynes that the principal criteria for selection of cases and timing of cases was their ability to favorably impact the 2006 elections. He had told him he wanted the cases brought on preferably right after Labor Day, and he wanted gory, good material, people where there was evidence showing that Americans had been killed, and he wanted the evidence brought on preferably a week or two before Election Day. In the course of these discussions, Haynes had also said, but some of these cases are very, very weak and they may produce acquittals. And Haynes, remember now, the man who sits above in the command system, above the judges, hearing this, stated, "No, we can't have that. There will be no acquittals." Well, in addition to Davis's resignation, 6 other prosecutors resigned. Prosecutors resigned, saying, and many of them corroborated what Mo Davis had said. Now, all this is out there, and I think most of you have probably not heard any reports of this in the media, because most of our major media decided it really wasn't terribly interesting. Just, scandal in the background. So it didn't get heavy treatment, certainly not in a major broadcast news. Well, shortly after that, the discovery controversy heats up. The prosecution is trying to submit into evidence some videotapes concerning a firefight in which Americans are being killed. It doesn't really involve Omar Khadr, but it's potentially quite inflammatory. People would see American soldiers died and get whipped up. The military judge says, I didn't really see the probative value of this for the case. He's making quite plain he's going to exclude it. And what happens? 5 days later, the footage is being broadcast on CBS News in the 60 Minutes segment. So that, most of the potential jury pool is seeing this evidence that the judges decide to exclude, and CBS subsequently discloses it was furnished to us by a member of Vice President Cheney's staff. And this is one of a whole series of reports come out that show Vice President Cheney and his staff are directly intervening in these proceedings, attempting to manipulate them, pressuring prosecutors, trying to get counsel and others removed. I won't go into all these cases, but certainly the evidence case begins to really mount, especially in a number of other cases, including one involving David Hicks in Australia, where Australian newspapers subsequently discover that when Dick Cheney, and this is about the same time, traveled to Canberra, Australia, met with Prime Minister Howard. Prime Minister Howard told him, we're taking a thumping in the polls. Elections are just around the corner. You've got to help me, Dick. And what you've got to do is just get rid of this case involving this David Hicks fellow. So Hicks had been high up on the list of people to be prosecuted. In fact, the chief prosecutor had already given a speech about how he was a vicious murderer who killed coalition troops or assisted people who did. And suddenly we discover, within a matter of a few days, that there is a plea bargain deal with Mr. Hicks, and whereas prosecutors had sought to put him in prison for life, now he's just going home to Australia free. That's the end of that. The prosecutors tell us the first time they learned anything about this plea bargain was in the courtroom when it was announced. So a plea bargain that the prosecutors don't know anything about, that Vice President Cheney personally seems to have negotiated. So here we see the Vice President of the United States and his staff stepping in, manipulating all of these proceedings. Not the normal course of justice as we know it. So there are a whole series of additional motion practices going on here. The judge hearing this case, a fellow named Colonel Brownback, seems to be listening very carefully to all the objections that are raised, and he rules against the government in a whole series of these motions. So he rules for the government on some of the major challenges, but when defense say, we're entitled to know who the witnesses are that are going to be brought for the prosecution, we're entitled to see the entire prison custody records, we're entitled to see other tapes that may have been made, the judge listens and says, yeah, you are entitled to see all those things against the strenuous opposition of the government, and so he enters an order saying government is to produce all of this, and when the government fails to comply with his order, he starts putting pressure on the government to comply. So what happens after that? Well, the judge is removed. From one day to the next, we're told Colonel Brownback is no longer presiding in this case. Normal, routine, administrative, housekeeping matter, and the new judge will now preside in the case. And the new judge surprise, surprise, has a very different attitude towards the government and these discovery issues. The new judge, Colonel Parrish, who seems to be just generally a very competent, fine judge, but he also seems to side with the government on these issues over and over and over again. So, I mean, maybe it is just a perfectly routine housekeeping matter, but I'll tell you in terms of legal practice, when you have a trial actually underway and the judge is removed, it's not his decision, he's stepping down for surgery or something like that. No, it comes as a shock to him. He's just removed and taken out of the case, and the military authority appoints a new judge to hear it. That is not the way we normally conduct legal procedure. Now, in 2008, a videotape is shown on television in Canada of Omar Khadr being interrogated by Canadian intelligence officials in Guantanamo in 2003, and what we see is this distraught teenager who is crying and pleading to be able to return to his family. And it's a very gut-wrenching thing. It's on television in Canada, and immediately after that, litigation's brought in the Canadian courts, saying the Canadian government misbehaved, violated his rights. He's being tortured in American custody in Guantanamo. Now, to the other amazement, to the astonishment, actually, of Canadian legal scholars, the Canadian courts, all the way up to the Supreme Court, sustain these complaints, ruling that, yes, indeed, this person is a Canadian citizen. His rights clearly were violated by the Canadian government. The Canadian government actually had an obligation to intervene to get him out of Guantanamo, certainly had an obligation not to cooperate with the Americans in any way. And by the way, these Canadian courts, while not making formal rulings about torture, they're all entertaining the allegations that he was tortured and finding these allegations plainly credible, all the way up to and including the Canadian Supreme Court. This right after the ruling of the Canadian Supreme Court, Judge Parrish listens to a motion brought by defense saying that the legal advisor to the convening authority, Brigadier General Thomas Hartman, was attempting to politically manipulate and drive the case on political instructions. Not very clear what they meant by the political instructions. Most people who look at it think Vice President Cheney's office is involved here. And the judge, hearing the evidence for all of these accusations with a lot of live testimony of people, concludes they're not just credible, they're completely sustained and true, and therefore a general is banned from involvement in the case based on clear and uncontroverted evidence of attempts to politically manipulate the case. And then we come to the election of Barack Obama. After being elected, President Obama requests a 120-day suspension of the Omar Khadr case, as well as all the others that are pending, saying that he's going to reassess them and make his own new determinations about which cases should go forward. And while this is going on, there's a good bit more information that comes to the fore, being put forward by the Defense Counsel. They discover an internal Defense Department document prepared and issued in Guantanamo that instructs the interrogators who are dealing with Omar Khadr and others to destroy evidence of their interrogations. They should take their notes, they should burn them, they should trash them, so that there will be no evidence remaining to document what actually happened in the interrogations and the event of later trials. In regular legal proceedings in the United States, that would be called obstruction of justice, and it would be called a felony. It would send people to prison. In any event, the government does not dispute this when it's put forward by the Defense Counsel. They essentially acknowledge that this is what has been done. The government also tries to block an examination of Omar Khadr by psychiatrists. They attempt to block a physical examination of him by medical doctors, but the court rules in favor of this access, and he is examined. And what we see is that he had been almost blinded, or he is blind in one eye as a result of wounds he received in custody in the United States, and that he received a hole the size of a Copenhagen chewing tobacco tin, is what the report states. Also, while he was in custody, this occurred. Then we come to the last stage of the proceedings. Evidence is taken by interrogators. The traumatic events that surrounded the killing of an American serviceman are presented, and two key government witnesses put forward by the prosecution state that they actually have no evidence suggesting that he was involved in the shooting of the American Special Operations figure who died, and with respect to which he's being charged in this case. The report, the after-incident report, is also submitted. It in no way suggests that he's involved in this case. In the midst of that hearing, the last day, the defense counsel collapses. You probably heard that press report. Had to be taken off to a hospital, and the trial was continued for 30 days pending medical evaluation of Omar Khadr's defense counsel. So that's where this case stands right now. And I think it's, you might think that this is the sort of melodramatic material that would fuel an afternoon American soap opera. But in fact, I would say, from a legal perspective, it's like watching a train wreck in slow motion. It's a terrible case, and it's terrible. I'll just view it from the perspective of the prosecution. I think from the perspective of competent, effective prosecution, this case is a total nightmare and disaster. And I'll just put aside the question of is he guilty or is he innocent of these charges. I think the model that we should use in looking at this is this historical model. That is the Nuremberg model. What happened at the end of the Second World War? And that is, in fact, I think, we have quite a few refinements since Nuremberg. We have the tribunals that were created for Yugoslavia and Rwanda. We have a tribunal in West Africa. We've had a special process for Cambodia. But Nuremberg, to a certain extent, still states the major concerns that great powers have when they bring war tribunals of this sort. And I think we should say what they are. So they always talk about justice. They frame this in terms of justice. And to a certain extent, of course, bringing proceedings of this sort in the war on terror, the U.S. does have a strong interest in justice for the victims of 9/11. But that will be met by picking people who really were involved with 9/11 and as to whom the U.S. has clear, convincing, direct evidence that shows their involvement in these sorts of heinous crimes. Another major objective that goes with these sorts of proceedings is for a power in a conflict to show the righteousness of its cause, that it deals in a just way with those who are its opponents. And that may be terrible justice, but it also is justice that's recognized as fair around the world, both in procedurally and in terms of substance. And the examples of all these tribunals I just cited, also there's another major aspect, and that is to show a big community. So in the case of Nuremberg, we're talking about demonstrating to the Germans or the Italians or the Japanese the nature of the heinous crimes that were committed by their leaders. It's a vehicle to demonstrate that by presenting this clear evidence. Same thing happened in the Rwanda tribunal, Yugoslav tribunal. Remember, in Yugoslavia, we had a lock-in by Serbians, for instance, supporting their government. This was an opportunity to show, no, these people really were heinous criminals and they did terrible things, and you should see this evidence, bring it all in. So if we take this as the essential standard, there's simply no way this case, Omar Khadr, which is the showcase with the revival of the commissions, serves the major legitimate purposes a power has in bringing these sorts of war crimes proceedings. And in fact, I think there are 4 different ways in which it is about as bad a case as you could imagine. So the first is, by bringing the case and putting it forward, the U.S. is being exposed for its failure to abide by its international law commitments. The rights of the child, child warriors, the Geneva Conventions. The Geneva Conventions, as the Supreme Court has ruled, include in this case at least Common Article 3, and Common Article 3 states that you can convene and hold trials of this sort, but it's only through what's called a regularly constituted tribunal. Let's go back and look at all the things I described here. Prosecutor resigns, talking about corrupt political manipulation. Judge shockingly removed. Evidence suppressed and introduced outside the process. All these things will be viewed as making this not a regularly constituted tribunal. So it violates the Geneva Conventions. I think that's like an open and shut case. Second, the actual evidence against Omar Khadr. Taking it in the best light for the prosecution, it's a really weak and confused case. So in the main charge, the prosecution has already put on evidence, that contradicts its claims. The prosecution also put on evidence in which a soldier testified to having shot Omar Khadr in the leg when he had surrendered and was disarmed down against a wall, which actually is a war crime under the Geneva Conventions. The prosecution offered this into evidence in the proceedings. What were they thinking? Not only no strong case against him, they are putting in evidence that is very, very damaging to the United States. There was no need and no reason to do this. I don't understand why they did it. Third, because of the legacy of Abu Ghraib, Camp Nama, Bagram, it was really essential, and this is a major burden for these prosecutors, they had to prove their case without using evidence induced by torture. And in fact, that's all they're doing here. The only evidence they've got for Khadr having been involved in the death of this man is a confession that they extorted from Omar Khadr. In the same session, by the way, in which he said he had tea with Mir Arar and Osama bin Laden in Afghanistan, which, of course, the U.S. discovered was total fabrication, obviously untrue. He was telling his interrogators what he thought the interrogators wanted to hear. It clearly wasn't true. But that's their major evidence. Okay? So their major evidence is directly linked to torture. Disaster. Disaster for the prosecution. And in this case, the judge is saying he ruled against the in limine motion to strike torture-induced evidence, saying, well, this young whippersnapper didn't testify in support of the motion, so I'm going to find there's no basis for it. And of course, all the outside observers are saying, oh yes, that's the judge who was put in place when another judge raised objections to what the government was doing, so that really doesn't look very credible. The United States historically for decades has objected to military commission trials of civilians on precisely this grounds. Namely, a military judge will never question techniques or procedures that have been authorized by military authority. Will not question that because of chain of command and other things. So the U.S. took the position that military commissions, at length, they took this position with respect to the military commissions in Chile. They took the same position with respect to military tribunals in Argentina, in Peru. And here, by this same argument, used by the United States, this is a bogus approach. And finally, and this I think is the thing that has most people in the Obama administration unnerved, the entire case against Omar Khadr is premised on the idea that he, as a civilian who shot a soldier in wartime, is committing a war crime. Okay? To put it mildly, that's an eccentric view of the laws of war. The laws of war are designed largely to protect civilians. And certainly there is no scholarship in the laws of war that states this anywhere. The U.S. has made it up right now. But let's just put that aside. Aside from that, is it in the interest of the United States to advance this view? Of course not. The United States today has developed and deployed a vast paramilitary army directed by the CIA. Do not buy Bob Woodward's new book, but he talks about this at length. Probably 6,000 soldiers in this paramilitary army in Afghanistan alone, okay? That's only a small part of the story. We also use more military contractors than soldiers by a very substantial margin in both Iraq and Afghanistan. And that includes military contractors who bear arms and use them with lethal force against civilians. And in both theaters, we're placing heavier and heavier reliance on private security contractors as replacements for uniformed military personnel. And then we come to drone warfare, by the way. Drones being operated, controlled largely by the CIA, using civilian contractors to build them, to maintain them, to direct them, to arm them, to target them at every stage. Civilians using this lethal force. So, under the arguments that are being advanced by the prosecutors in the Khadr case, all of these American employees, including the CIA people, their paramilitary army, the people who are using the drone, they are committing war crimes, and they can be prosecuted for these war crimes. This is the reason why, while the prosecutors are saying this in Guantanamo, people like the judge advocates general are in a state of apoplexy about this. Not to mention the lawyers at the State Department. And I've referred to this as the Khadr boomerang. They make up this cute argument and they use it perhaps to get a conviction in this military commission case, but it's going to come right back at them in a big way if they succeed. So why are they doing this? Why? It's blowing up in their face. It's a disaster. It clearly is contrary to what Barack Obama promised he was going to do. So why didn't he just reverse course and pull this case? What happened? It's very, very difficult to dig deep inside the government and find out how this happened. But I've been trying to do it. And this is what I learned. When the 120-day period was announced, Obama's people essentially went to the prosecution staff and told them, reassess your case in light of these new criteria we're giving you. Tell us whether you think it's a viable case, whether it meets these new criteria, and whether you think we should continue. So they took an extremely hands-off, light touch on this. And it's not at all surprising. I mean, what happened is exactly what any sociologist or psychiatrist would tell you would happen. We have a phenomenon called lock-in. You have a staff of people who've developed this case, who put it forward, who are already engaged in trial of the case. They're not going to come back and say, oops, we made a mistake. No, so of course they all come back and say, no, we did everything by the rules, we did everything by the book, everything's proper, it should go forward. So of course in almost all of these cases, this is the recommendation that comes back from the prosecutors. So you would expect the Obama team to say, well, nevertheless, we're going to overrule you on this, and for other reasons, for what we call valid policy reasons, we're going to stop this prosecution. Now, it's true that prosecutors are supposed to act with a broad degree of latitude and independence. The executive's not supposed to step in and second-guess every prosecutorial decision. But the executive is entitled to give policy direction on prosecution. This case was an easy one that the Obama administration could, without violating any of the prosecutorial autonomy rules, have stopped. How? By saying, no, unlike the prior administration, we treat our treaty commitments under the International Convention on the Rights of the Child and the Child Warrior Protocol seriously, and there's no way to square what's been done here with those treaty commitments. And the evidence that's going to come in is actually going to wind up embarrassing us and demonstrating our failure to comply. So therefore, we're just going to pull this case, and we'll deal with it by plea bargain or send the guy back to Canada or something like that. Which, in fact, is what one of the Judge Advocate Generals 2 weekends ago told me is what obviously should have happened. Send the kid back to his mother in Canada and be done with it. Eminently reasonable solution. So why is the administration not reaching in? We discovered that there's a shift that occurred in the White House. So in the first days of the Obama presidency, Greg Craig is the person who drafts these orders. He pushes them forward. Greg Craig makes a number of speeches during the campaign and after the election saying the president's completely serious about all this and he's going to put it through. The drafts he does show, actually a pretty serious intent to implement. And I'd say Craig aligns very closely with another person here, Phil Carter, who is Deputy Secretary of Defense responsible for detainee affairs, who also was involved in the Obama campaign, deeply involved in the formulation of even some of Obama's speeches and pledges in this area, and clearly was totally committed to doing it. Within 10 days of one another, Greg Craig and Phil Carter resigned their posts. And 3 other people who are closely involved with them in this same area also resigned their positions in the administration. What happened? I don't know what happened. I'd say it's very clear that several things happened. One is that there was a major policy confrontation inside the Defense Department about something to do with the prisoners at Guantanamo and prison policy generally. I don't know exactly what the controversy is, and I know that the president's team from the campaign took one position, Secretary Gates and others took a different position, and Secretary Gates won that round. And it also appears very clear that there was a corresponding conflict inside the White House. And the corresponding conflict inside the White House is between Greg Craig, President's counsel, and David Axelrod, principal political advisor, and Rahm Emanuel, his chief of staff. So Rahm Emanuel, at this time, he's not a lawyer. It's pretty clear that Rahm Emanuel has concluded that he believes national security issues generally are a Republican issue. And it's best to disarm this issue by simply providing continuity of the Republican policies and not making changes. And the way this gets presented, in fact, Rahm Emanuel appears before the media several times saying, the president made a pledge, look forward, don't look back. And that translates into, we're not changing, we're continuing policies from the past in many of these areas. And Axelrod seems to back him up on all of this, saying he's done the polling, not our issue. Best for you to lay your ground for the next election in 2012 on the basis of domestic policy agreements. Rahm Emanuel then also starts to negotiate a settlement with Lindsey Graham of these issues, which appears in the media several times. And this settlement involves Rahm Emanuel evidently discussing with Lindsey Graham specific named defendants whose cases would be taken out of the list that were to be tried in federal criminal court and instead be put into the military commissions. And by the way, that's illegal. This is one of the big charges that was raised over and over again against the Bush administration, that Karl Rove was manipulating cases in the Justice Department, which, by the way, he clearly was. But Rove was smart enough to do this very cleverly and very quietly. And here we have Rahm Emanuel talking about it to reporters. Clearly unethical. Eric Holder steps in saying, you know, actually we should be prosecuting you, Rahm, or we should be doing an investigation. You're not supposed to do this. You can talk about policy all you want, but you do not make statements about who we're going to be charging on what charges before what courts. Not your responsibility. And that would be viewed as political manipulation of the criminal justice process. After that, Rahm Emanuel suddenly got very quiet and didn't talk about things with the press, and his negotiations with Lindsey Graham also stopped. In fact, last week, Lindsey Graham stated that, gee, it's as if in the middle of May, which is the time that Holder got back to them, a drone was dropped on Rahm. All our discussions came to an end. So, what's the view of Barack Obama about all of this? Nothing suggesting he ever changed his view about policy and what was right at any point. None. Also, no clear suggestion that he decided that Rahm had the right approach as opposed to Eric Holder. What happened is we came to an impasse in resolution of the policy issue and a failure to implement his campaign commitments. So I think we could say it became hostage to partisan politics. And the president also took the advice of his political advisors that this wasn't a smart issue to be pursuing at this time. So I think that's where we stand right now with the Obama administration. Let's say it's not a conflict or an argument that we've lost with President Obama, but it is a matter that's been stagnated for political reasons inside the White House. And as we come to this midterm election, let's assume we see a dramatic shift in favor of the Republicans in Congress. The window that's been open to implement the policy with large Democratic majorities is going to pass. And then we'll be dealing with a Congress that will in fact be in a position to block implementation of these policies. So it's a missed opportunity. That's essentially where I see it right now. And I want to talk just a second about JSOC, which figured in this a little bit. So as I noted, JSOC has been involved in some of the deepest and darkest problems during the War on Terror. And that included the operation of a separate series of black sites, most important of which is the so-called Black Prison. It's located on the perimeter of Bagram Air Base. We know that JSOC also operated a detention facility at Camp Nama, another one in Mosul, another one in the Persian Gulf, we don't know exactly where, several forward operating bases in Afghanistan. JSOC will formally state it has no detainees. It views all of this as only filtration and intelligence gathering, not a detention operation. Very, very technical distinction used to loudly state no when they should say yes in response to question.